number 169, the people of the state of New York versus Matthew A. Davis.
Good morning.
Good morning, Counsel.
May it please the court, my name is Laura Bittner, and I'm here representing the Niagara County District Attorney's Office. I don't wish to reserve any time for rebuttal.
Thank you.
There was 2 points in our brief to this court, and first being that the people proved beyond a reasonable doubt that the assault that occurred on the victim, in this case, at the hands of the defendant, was a sufficiently direct cause of the defendant, or I'm sorry, of the victim's death in this case.
Your expert witness though from the ME's office using a but-for?
They did.
So how does that satisfy reasonable doubt?
The only time that but-for was used was during that testimony of the medical examiner. I'd point out to the court that the judge charged the jury properly. Obviously, the jury is presumed to follow those judge's instructions. And what that but-for causation was simply a starting point. It's the first step in the analysis. So yes, but for the defendant entering the victim's apartment that day, beating him up, he wouldn't have died. We're at step 1. And then the medical examiner went on after that point to explain, okay, let's take this a step further. Why was this a sufficiently direct cause? Because we had an obese victim who, given the information we know now about obesity and the health problems that it can cause, in the same way we consider, an elderly person might have health problems, and that in some of the other cases this court has examined, has the potential to have heart disease, to have heart
Counsel,
problems.
does the court have to take into account the knowledge or experience of the defendant? I mean, some people might know that obesity causes heart failure, heart disease, but what about a young person who isn't thinking about things like that? I don't know how old the defendant is here, but what about someone who may not have that kind of life experience?
I think considering the prevalence of that information that we have in the media now, the articles that are written about it, the things we see in the news about just simply eating healthier, that obesity can cause heart disease and all these problems, and that I think that it is within the average person's knowledge at this point.
To understand if I punch you in the jaw, you might have a heart attack because you're very, very overweight?
Given this, when you have a victim like this in front of you, yes. And given the beating that occurred here too, we're not just talking about one punch that broke his jaw. We're talking about a prolonged blunt force injuries that occurred over and over again. And part of, I think, what the Fourth Department didn't address.
Did the ME suggest that was the cause?
What they suggested was that
prolonged struggle that you seem to be talking about?
the longer the struggle, the more brutal it was, the more strain you're putting on a person's heart. And when you have someone whose heart is already somewhat damaged, you're looking at increasing their blood pressure, you're increasing their heart rate. And so the longer it goes on, the more brutal it is. I think that increases the risk, and that's
Do you
what
have
we
to
have
be
here.
obese or just very heavy?
I guess visually what this defendant was looking at in front of him, whether he's making a distinction between very heavy or whether he's officially obese on your BMI. I think visually he could say this was an overweight person.
There are some cases from the Court of Appeals on the issue of the heart attack involving elderly victims. I think Anthony M. is one, and People v. Cable, and also People v. Ingram. And those cases, if you're familiar with them, you want to address those, because they seem to argue that, they don't argue obesity, but you have to be aware of the condition of the person, I guess, in the analysis. That would be the fairest way to put it.
In that same way, you're looking at someone who, you might not exactly know that they're 86 years old, but you know that they are elderly. In the same way, you might not know whether or not their exact weight makes them officially obese, but you can look at someone and see that they're overweight. And in those cases, we have even a further attenuated someone that died 10 days later in Anthony, or someone that died 55 hours later. This was almost immediate. When you look at the evidence by the crime scene experts and by the blood splatter experts, once Mr. Bradbury went down, he never got back up again.
Yeah.
Counsel, is there any significance we should attach to the fact that the ME classified this death as undetermined?
I think that actually perfectly showcases what the jury was supposed to do here. I believe it was in the redirect, the ME explained that they went with undetermined because it's not simply a homicide. It's not simply someone walking up, shooting someone in the heart, they're dead. That's easier to determine. Nor is it completely natural causes either. So you have to look at all of the chain of causes that went into effect here to determine the cause of death. And I think the ME almost said that's what the jury is here to decide, is to look at, okay, we have this beating, we have the strain that causes on a heart, we have a person who we're looking at as obese or overweight in front of us, and that's what ultimately causes the death.
Would you care to address the admissibility of the video surveillance tape?
I believe those objections went more so to the weight that was given of the tape, as far as there was extensive, I believe, in Mr. Brandt's brief, as well as the testimony at the court, as far as, you know, some of the jumps in that occur in the video. It's something for the jury to take into account as far as weighing its weight, but not its ultimate admissibility.
Is your position that they didn't preserve this question about, the foundational question about admissibility, that the question is all about the weight?
Yes. Any further questions?
Thank you, Counsel.
Thank you.
Ms. McGrath?
Good morning, Your Honors. My name is Patricia McGrath. I'm here on behalf of Matthew Davis. And I would like to begin by discussing the issue of the heart attack. Heart rate's a little interesting concept for me at the moment, but I will soldier on here. The medical examiner, which of course is somebody who didn't actually perform the autopsy, but did have an opportunity to review the findings, uses a but-for test.
Well, I know they said that, but he's 6'1", 270. There's a bunch of them that are going to be playing football on Sunday. When they talked about obese, when I first looked at this, I thought, we're looking at some lumbering person who can barely get out of bed in the morning and sits in a chair all day, and that wasn't necessarily the case here. And isn't she right? The CGI was followed to a T. And then they said it's not the but-for test, it's a direct cause, and that's what the jury was given. And don't we have to presume that they followed that instruction and came to the conclusion they did?
Well, I think that as the appellate division stated, the judge gave the correct jury instructions. However, the combination of her testimony and the fact that the heart attack for someone who is 41 years old, unlike the victims in Anthony M. and the
But the
Buchanan
standard
case.
was right, is my point. In other words, if we're looking at the question of law as to whether or not the jury was given the appropriate standard by which to make a determination on the facts, they got the right standard, and they reached the conclusion that it was a murder, it was a homicide. So how do we interfere with that?
Because as the cases, the line of cases that talk about the necessity for felony murder, that there be a sufficiently direct connection between the incident and the death. We have a discussion by the ME on the witness stand with regard to time of death, although we don't know the
But
time
counsel,
of death.
to get to Judge Piggott's point in a different way a little bit maybe, isn't, with this instruction, wouldn't we have to say there is no version of the ME's testimony and the rest of it that would support this verdict? I mean, that would really be the standard, right? We would have to say there is no rational way this jury could have applied the correct instructions and come up with a guilty verdict.
Under legal sufficiency?
Right.
Yes.
It's kind of an interesting question because of how we look at causality. So are we talking about that the only way that this victim would have passed away would have been because of the robbery? Or are we talking about that it was a significant contributing factor in causing it? And Which is it for your argument? The reason I ask that is because Anthony M. in some of those cases talk about it being a link in the chain, and the language is used that the actual contributing factor forged a link in the chain of the cause of events, which is kind of normal proximate cause. But if we accepted your argument, I think we'd be saying that there has to be, but for this happening, wouldn't have had a heart attack. It wouldn't happen. It's got to be the sole contributing factor almost. Do you see the distinction I'm making here between a number of factors that could be significant that could cause it, or the sole factor that could cause it? And that's the problem I'm having with your argument, that you're arguing that it would almost have to be the sole factor that caused it.
Our argument, Your Honor, is that, while it does not have to be the sole contributing factor, that it has to be, more significant than what was testified to.
So let's assume that's true then. We'll take that. So then how is that not a pure jury question? In weighing the different factors? Because obviously there's more than one factor. Obviously weight was a factor in causing it. Stress, that happens over time. It's not just at this particular moment. There are a number of factors, but was this a significant contributing factor? How do we distinguish those here as a matter of law?
I think that because we have testimony by the medical examiner that the report itself, as I think perhaps it was Judge Rivera had indicated, that the report itself shows undetermined. Maybe, I apologize, might have been used. But the cause of death was a question for that the, I apologize,
So you're
the
really
manner
saying
of death is.
we should look at the testimony then of the medical examiner making our determination, and so you're saying that's what's insufficient?
With respect to the felony murder. Then of course, we have the issue as well with respect to the videotape.
Well, before you get there, go
Sure.
back on this death again. Your argument seems to end up being because the medical examiner's report, because it says what it says, you can move to dismiss this right at the grand jury. It says cardiac event, QED, I win. It's not a homicide, unless the CME or the medical examiner says it's a homicide. The DA has no right to charge somebody with murder.
No, I'm not saying that, Your Honor.
Okay, so that means that because the medical examiner said it was a heart attack, does not necessarily mean it would not be a homicide. The jury was given the instructions that there has to be a direct cause of it. They made a factual determination based upon that standard using that medical examiner report. What's the flaw?
Your Honor, as I said, I think that the flaw is that there has to be some sufficiently direct, to use the language of the cases, sufficiently direct connection between the action and between the, even though it's not a but-for test, it still has to have some significance.
Well, what makes this insufficiently direct as a matter of law? What is it that's missing as a matter of law that says that a jury could not take this expert's testimony and find the defendant guilty?
I honestly can't say that it would be as a matter of law. So that it really goes to the decision of the appellate division and its analysis, which they have, of course, the ability to do. And they agreed with our argument that it wasn't sufficiently direct, and consequently, it wasn't reasonably foreseeable.
The people are also arguing that in addition to the ME's testimony, and you're correct, it's not the ME who did this particular autopsy, but the ME's testimony and so there's other evidence anyway. Sort of the blood spattering, the fact that it's a struggle to draw on. Let's assume that one would be persuaded by your argument about the ME's testimony. Why doesn't the rest of the evidence, though, get you past the hurdle? Because you focused only on the ME's, but I'm saying the people have argued, but there's other evidence.
Yes, the blood spatter evidence shows that there was a struggle. But we also know from the autopsy report that there were no serious injuries. There was some contusions, there was, a fractured jaw.
Does there have to be injury? What if instead of just having a fist fight with the defendant, the victim came to the door or the defendant barged in and had a gun, and then the victim immediately has a heart attack and dies? Would you say there's no direct connection between what the defendant did, barging in with a gun, and the heart attack?
Well, I think that goes to the question of foreseeability, Your Honor, because, I think it's a lot more foreseeable that somebody would react in such a way if a gun is being pointed at them than if they're getting,
So it has to be a weapon?
No, I'm not saying it doesn't have to be a weapon, but I think your hypothetical, is a fact pattern that I think would more reasonably support the foreseeability.
Ms. McGrath, would you like to move to the admissibility of the video surveillance?
Yes, as we indicated in our briefs, I think that first off, I think that the matter was preserved because there was an immediate motion upon the testimony of the expert that this really was not a fair and accurate representation of what took place on the evening in question. That motion in and of itself, as well as the renewal of it at the time of the trial order, I think sufficiently preserves the matter for our consideration today. I think that although there are certainly a number of arguments proffered by the appellant's brief with respect to how you authenticate a video, that the one that they didn't get to is the one that we believe is the most troubling, which is that it's not a fair and accurate representation. Consequently, that comes out, then it's a little bit like a house of cards with respect to the underlying felonies.
Thank you.